Court is going to sentence you to 45 years.
You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, suicidal thoughts, plus 4 different attempts, depression, anxiety due to trust issues, and problems with family members, because I still hate your guts and wish you the rest of your life in prison.
Court is finding violation of condition number 4 true. The court is going to find you guilty. The court will sentence you will sentence you to 8 years in the prison.
What was the consequence again?
Oh, you're going to prison for 8 years.
I'm going to prison for 8 years.
Yes. Court is calling 2022 CR 7283, State of Texas versus Christopher Brent Davis. I have parties announced for the record for the state. For the defense.
For Mr. Davis.
Suzanne Kramer, also for Mr. Davis.
All right. Mr. Davis, you entered a plea on May 7th of no contest. The court found there was sufficient evidence to find you guilty. The court deferred finding of guilt. You're coming open to the court. Have both parties had a chance to review the report from probation?
Yes, Judge.
Yes, Judge.
Any objection, state?
No, Your Honor.
Defense?
I have a couple of corrections, Judge.
Yes.
Regarding his discharge from the Navy, it was stated in there that it was less than honorable. I think his actual discharge was a general under, what's it called? Under honorable.
Okay.
General under honorable, not less than.
Okay.
And at the very end where he states a few things he wanted you to know, he referred to something that happened to him at age 5, but a subsequent conversation with his mother that was determined to have happened when he was at age 2.
Okay. All right. Any witnesses?
Not from the state, Your Honor. We just have an argument.
Just Mr. Davis, Judge.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do have a couple other witnesses. Can we take them first, Judge?
Sure.
Thank you. I'm sorry.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right. You can lower your hand. State your name for the record.
Christopher Brent Davis.
All right. Defense.
All right, Christopher, what is it that, other than what you already stated in the PSI, what is it that you would like the judge to know before she decides what your sentence ought to be?
Your Honor, there is no explanation. There's no rhyme or reason. Nothing would be able to be justified as far as what my actions did. There's every day that I live with regret because it's not only one person I hurt several people, including my own children, my own biological children. The only thing I can ask is for forgiveness from them, and I will accept whatever consequence that you've seen as punishable, Your Honor.
All right.
And Judge, this is the part where I do, like I tell my wife, if I tell you something from here on out and that you can accept it 2 ways, one to make you mad and one to make you not mad, I mean the one that makes you not mad. Okay. So, question that we have is what's appropriate punishment for this type of case for Mr.
All right.
Davis?
I'm sorry. Just 1 second. State, you don't have any questions, do you? All right.
All right.
All right. Thank you for giving your testimony. And so the range of punishment for this offense is 5 to 99 years or life.
That's correct, Judge.
So, state, what are you requesting?
Do you want my request and my argument, or just my request? Right?
Your request.
You're asking for life, Your Honor.
All right. So they're asking for life. Defense, what are you going to be asking for?
Judge, we're asking for 20.
All right. So now, state, I understand why you're asking for life. Defense, I understand why you're asking for 20. So, one, I'm not going to sentence him to life. I've taken in consideration his testimony. I've taken in consideration the testimony from both his parents. And I want the parents to know, at some point in time in life, your actions are not the cause of your child's actions. Because how old are you?
38.
All right. So he's 38. At some point in our lives, when we're making our decisions, no matter what happened in our past that was horrible for us, or maybe our parents made a mistake in how they raised us, at some point, your actions are your own. All right. So I'm not going to sentence you to life, but I'm not sentencing him to 20. It's an egregious offense.
And if I may offer some perspective on that, Judge, that's what I
Yes.
intended to do. So we agree it's egregious offense. He agrees it's an egregious offense. It's something that went on for about 6 or 8 months from what we can tell from stipulated evidence. And yet the same day that we were pending, that we actually entered our plea, there was another person pending who's had a death of a child, injuries to a child causing death. And the very next day, this same prosecutor's office, same prosecutor
I'm gonna object to this
offered
line of,
them 18 years.
All right. Okay. So here's the thing. Defense attorneys, you all know that sometimes people can be at the Bexar County Jail or at the prison. Sometimes there are people at the prison for murder. They get 5 years. Somebody else at the prison for murder, they get 30 years. Every case is different. And there's a reason why people are given certain times. And there are reasons why sometimes this court follows a plea, sometimes that I do not follow the plea. Now, what I'm telling everybody, the state has asked for life. State can ask for whatever they want. I've already told the state, I'm not giving him life. So the argument about what they did in other cases, that's not an appropriate argument. We're here for this. Now, if somebody wants to make an argument that the same fact scenarios, as we would call it in law school, that the case is on all fours, if there's another case that's on all fours with this case, where the state gave somebody 12 years or 10 years, then we need some explanation because maybe things are not being done fairly. So if you can present a case to the court that's on all fours with this case where the state made an offer of something less than life, I think it's relevant. I'll hear it because maybe something else is happening in the office.
Well, Judge, and I would offer you something on that. I think it's on all fours. I don't know whether it's on all fingers and toes, but there was a case in the 227th where the fellow was charged with continuous sex abuse of a child, same as Mr. Davis. He was allowed to plead to aggravated sexual assault of a child, same as Mr. Davis, but he was given 12 years.
All right,
For a 4-year-old child.
So let me ask you this. Was that a case where you had a defendant who's alleged to have pretended to be a juvenile online and then tricked his stepdaughter into allowing him to engage in sexual activities with her by pretending if she didn't, the new friend that the defendant had created, life would be in danger?
Of course, Judge, I cannot offer you that, but they just, for selective prosecution purposes and sentencing purposes, substantial similarity, I think, is what they look for. And in this case, the same charge, same reduction, a 4-year-old instead of a 14-year-old, and this fellow gets 12 years and the state wants life. I know you said you're not giving that to them, but this guy gets 12 years in a different court, and Mr. Davis is looking at whatever that you choose to give him. So
Okay.
that's the only reason I'm offering that, Judge.
Right.
And again, back to I'm not trying to make you mad. I don't want to visit my sins on my client.
No. Here's the thing. One, I don't get mad. I believe that everybody should be allowed their argument. I've been a defense attorney before. People should be allowed their argument. I've been a prosecutor before. People should be allowed their argument. I don't get mad. And what I can tell everybody, when you're in jury trial, if this were a jury trial, guess what? Defense counsel's state's closing arguments, that's not evidence. Evidence is the steps that I have. Evidence is whatever testimony I receive. Closing arguments that counsel do on both sides, that's spin. And hopefully the arguments they're making is in some form or fashion connected to the case that was just heard. All right, is there anything else?
No, Judge, I would just like to highlight, there is one other statement from Christopher in the pre-investigation report at the very last page. It states that he was the subject of a grooming himself when he was around 12 years old by a 39-year-old. We've discussed this, and again, Judge, he's not of the opinion that it's any excuse for what happened, and he doesn't even really know if it lent any substance or predisposition for him to have done this, but it's just offered for the court for contextual purposes.
All right. So I want to let you know that I heard all of the arguments. I internalized everything. And these are very difficult cases. Anytime someone comes open to the court, it's very difficult. And let me just tell you why it's difficult. This is the type of case where everybody will say automatically it's a life case, right? But I go on facts. I go on what I read. I go on everything. I go upon, experience I've had in dealing with specific cases. Because otherwise, if every case were a life case, then guess what? We don't even need to have a punishment hearing. It's just, this is what you did. We prove it. You get life automatically. So I look at everything. What you've done, of course, is something very bad. And people are going to be impacted for years to come. Right. So sometimes when I consider what to sentence somebody to, I think about their age. I think about protecting of the public. And there are many things that I have to consider. Like, for example, is somebody going to allow you to be around children again? That's something I have to consider. Like, what age will you be where people will see you and they will not say, oh, that's a good catch. Let him babysit a child. Those are all things that I have to consider because part of my job is protecting the public. And I also have to consider evidence that's presented. I consider the stipulations that you stipulated to. So this is what the court is going to do. Court is finding you guilty. There's to be no contact with the complainant. There's to be no contact with any minor. There's to be Chapter 62 registration. Court is going to sentence you to 45 years. Court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Sure.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, we can go off the record. Here's the thing. I want to let you know, just a second. I want to let you know that I appreciate the fact that you entered a plea to this, you entered a plea to it early, that when you came before the court, you didn't try to be wishy-washy on whether you did it or not. You are a person who truly took full responsibility for what you did. And I appreciate that you did that. All right. So can you mute us, please?
Yeah.
Yes.
Okay. Even after all you've done, after all of the activities you did and all the messed up things you did to our quote unquote family, I was able to fill myself with remorse, empathy, and sympathy for you. Now, don't twist it because I still hate your guts and wish you the rest of your life in prison. Also, don't be expecting forgiveness out of me. You might be able to convince other people, but you won't get it from me. You ruined a lot, but don't go raising your ego because you thought you ruined my entire life. You've only ruined things in it. You got away with it, or you've also improved my life. You got me away from you and Ashley. You brutally taught me how not to be so naive. You got the rest of my family away from you and Ashley and into a safer place. But most importantly, you found a way to wind yourself in prison. Here's a small list of all the things you've done to me, starting with the bad. You've made me relapse many times, gave me PTSD. You gave me a sleeping problem, suicidal thoughts, plus 4 different attempts, depression, anxiety, paranoia and trust issues, problems with talking about my feelings, nightmares constantly, fear of using any bathroom, gender questioning, panic attacks, caffeine addiction, slight smoking addictions, not being able to make friends easy due to trust issues, and problems with family members. Here's the list of good things you've done in my life. You put me into a position where I was being put with people who actually care for me enough to take Wyatt and I as their own children. That's it.
right, thank you. Is there anyone else? All right, Ms. Davis?
Yes, Judge.
All right, you may proceed.
So I'm not sure where to start or the things to say to you, but this is where I'm going to start. Almost 16 years ago, when we got married, you said you would never hurt me or my daughter, who was only a couple months old at the time, or any kids in the future that we would have together. And I believed you. As our marriage went on, you ended up breaking that promise. You made me believe that I was crazy, and to the point to where I had to see doctors, therapists, and I didn't have friends anymore. I tried to help you be a better person, and it made you mad. I had no real warning about who you were. I'm glad I finally realized it with the help of some friends that I did make, and I made it out 7 years later. I made it out before things got so much worse than what they already were. Separated, divorced, went to court for our kids. You made people believe that I was doing things to our kids, and I wasn't. You played mental games with me and would verbally abuse me as well. After everything that you put me through, all the tears and the 7 years, you had everybody still believing that I was doing all of this. But eventually, you were caught because you did it. Sorry. I've been angry, yelled, screamed, cried over everything, and I blame myself for it, for not being able to protect our kids. You're not half the person I thought you were. But after all these years, I realized that your actions say more about your character than they do about me. I hope that life gives you everything that you deserve and you live peacefully with your choices that you've made, because our children and I won't be losing sleep over you anymore. You are where you belong. I feel you not only need for me to apologize for things that you did to me, but to the rest of my family and to these kids. And I hope that you pray hard for that and that one day they can forgive you. But I also want to sit here and say thank you in a roundabout way, Chris, for everything that you've put me through, but because you've not only made me a stronger woman, but you've made me a stronger mother when it comes to protection of our kids. The kids have decided that they wanted to say something to you. Our daughter states that, to me, you were never really my father, only because you treated me like I was nothing, for always lying and never listening when I told you the truth, for robbing me of my childhood and making me have to grow up too
I'm gonna
quickly.
object to this.
All right, excuse me. I'm so sorry. The defense has raised an objection. I'm going to sustain that objection. Thank you so
Okay.
much for coming in to give your statements.
Thank you.
All right, thank you. Are you the same James Madrone who was placed on deferred adjudication in 2021 CR 2437 for the offense of failure to stop and render aid serious bodily injury on March 21st, 2022 for a period of 10 years? Is that you?
Yes, sir.
State.
Violated condition number 4. In Bexar County, Texas, the defendant, James Madrone, did then and there fail to report to the supervision officer as directed for the months of January and December 2023 in violation of condition number 4.
How do you plead to that? True or not true?
True, Your Honor.
State.
Your Honor, we waived the other violations alleged in the motion.
No objection.
All right. Mr. Madrone, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, I understand.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
It's not, Your Honor. We are we're going open. We are asking for the 10 years, Your Honor. I believe the defense might be heard on it.
All right. Defense, what are you requesting?
Judge, we're requesting that he be placed on probation, that he be given weekly UAs and intense supervision. Basically, Judge, this was a lot dealing with financial issues. He has 2 small children that he was responsible for, living with his grandmother at the time. He's now presently employed. I believe he has the resources now to continue taking drug testing and support his children. So I think basically, Judge, if we give him weekly UAs and ISF and put him back, not ISF, with intense supervision, that he's able to complete the probation successfully. You have anything to add, James?
Yes, Your Honor.
All right, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
James Madron.
All right, it says here that you didn't talk to the manager and you left when asked to stay in the lobby by the probation officer.
Your Honor, I was my grandmother, thankful for her that she helped me with my burdens when I had to do these reports and everything, and she would have my kids in the car while I'll be reporting. So at that time, I really didn't have too much time to be there due to my being responsible for 2 children. So that was just that at that time. That was it.
Okay, that doesn't make sense to me. Your grandmother is helping you with your children.
Yes.
And how old are your children?
3 and 1.
All right, so she's helping you with the 3 and 1 year old. So you're telling me your grandmother drives you to see your probation officer
Yes.
and then says, I can't wait.
Yes, Your Honor.
That doesn't make any sense to me.
It's just like I have real no support, really none. It's just me out there.
All right, so your grandmother is not supporting you.
Well, in a way she is. In a way.
All right, and then it says that they tried to have virtual meetings with you and you kept rescheduling and they allowed you to reschedule it and reschedule it and reschedule it.
Again, I had financial burdens.
So you didn't have a cell phone?
No.
You couldn't get a ride by via bus?
Your Honor, my grandma lived in Leon Valley and then she moved over there by Lackland Air Force Base. And I did not have reliable transportation.
Oh, no. I know for a fact that there's transportation by via for Lackland.
Oh.
And you know how I know there is that? Because one time I made a mistake and got on the looper, which I believe is the 510, and it takes you all around the city. And I was like, wow, this is where the bases are.
Yes, but where I had to report was over there by 1604 in Bandera, which
Via.
yes, Your Honor. They canceled that bus route. I know it sounds like if I'm making it up or not, but yes, they did cancel that bus route for that reason. That drive was very, very extreme.
Did you pick up the phone, call probation and say, hey, this
Yes,
is
Your
where
Honor.
I am? Okay.
Yes, Your
All right. Any other questions?
Mr. Madron, my name is Hank Wilkins. If I ask you anything you don't understand, just let me know and I'll try and rephrase it, okay? Do you know the last time you reported?
The last time I reported was
This year?
yes.
It was this year? So would you just promise learn that probation thinks the last time you reported is November? Did you ever do the CATS theft course?
No.
Did you do the CATS 2 theft course?
No.
Did you do the moral recognition therapy?
No.
Did you do anything on probation?
I had parenting classes that were available online, which I did do, and it waived over my community service.
I'm sorry to interrupt. How can you do the parenting classes online,
They
but
were
you
for
can't
free.
report? No. But you can't report to probation online. Explain that to me.
I did report to probation online every time I had a Zoom meeting. And when it was in person, it was hard for me to be able to report due to my lack of transportation.
Do you remember telling probation in January of this year, they're not gonna do anything?
No.
Do you remember telling them, I know the judge will reinstate me?
No.
You understand that when you pled to this offense, that's a third-degree felony, right? You're looking at up to 10 years in prison.
Yeah, I do understand. Yes, I understand.
And you knew that, and you still didn't do these conditions of probation, right? You didn't do the
No.
moral recognition therapy.
Not that I had faced financial burdens, so I did not have support from the mother of my children. She was attending school at the time, but now I have a reliable job. I have the means to prove to the court that I could be responsible in finishing my term with the probation.
Seems like the easiest thing to do would be to report, though. You didn't report at all this year, right?
No, because she said that she was gonna file a motion to revoke, and I had said that, okay, that we have to do what we have to do. That's simple. That's what I had said in that response.
I'll pass the waste, John.
Nothing further, Your Honor.
All right. Probation. Was there any restitution for Elise Perez and Kimberly Soto? All right. So this is what the court is going to do. The court is going to find violation of condition number 4 true. The court is going to find you guilty. There's to be no unsupervised contact with minors. With regards to punishment, state, what are you requesting?
Your Honor, we're asking for the 10 years of prison. This is a third-degree felony. This is a SBI, Your Honor. Some other cases were taken into consideration of this plea. The defendant had opportunities to plead in the division. He didn't do much of anything on probation. I was trying to get some more information today. None of the answers are very satisfying. So we're asking for 10 years from prison.
Defense, what are you requesting?
Judge, I asked that he be sent, continued on probation and sent to ISF for a period of time to get his thoughts together. Be able to get out on the street and be a productive member of society and also a father for his 2 children.
All right. Oh, yes. You wanted to add something?
May I address the question?
Sure.
Yes, I would like to say that I would like to suggest no tolerant probation where I may be supervising weekly UAs. I do not use drugs.
Mhm.
And or an outpatient program, intense outpatient program that I can prove to the court where I can be responsible in completing my probation successfully.
Okay. All right. This is what the court is going to do. As previously stated, the court is finding violation of condition number 4 true. The court is going to find you guilty. The court will sentence you will sentence you to 8 years in the prison. There's to be no unsupervised contact with the minors. Court will give you credit for any time served, and the court will request the therapeutic community. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it, and did you sign it?
Yes.
All right. You do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? All right. Good luck to you. We can go off the record. Here's the thing. I can't force them to place you in the therapeutic community. You'll have to request that. And then it's completely up to them whether or not they place you in the therapeutic community.
Your Honor, what was the consequence again?
Oh, you're going to prison for 8 years.
I'm going to prison for 8 years,
Yes.
and that's the done deal.
Yes.
Okay.
All right. Good luck to you. Okay. Texas versus James Madrone. Do I have parties announced for the record for the state?
Brian Grimmer for the state of Texas.
For the defense?
Ronald Geyer.
Did you understand you're charged with failure to stop and render aid, serious bodily injury? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Are you proceeding with sentencing?
Yes, Judge.
All right. Anything to say on behalf of your client?
No, Your Honor.
Where is Donkey Lady Bridge? No, it states in here that they had met you through a lease. OP1 said they were at the complainant's house when the group of males showed up in Unit 1. Unit 1 is the vehicle. She said they decided to go to the Donkey, D-O-N-K-Y Lady Bridge, but instead ended up driving around. Where is this Donkey Lady Bridge?
I'm not sure, Your Honor. I've never been there in my life.
Are you still driving a vehicle?
No.
How old are you?
21.
If you drug tested today, what are the results going to be? Before you answer no, that you are going to be drug tested today. Don't say just tell me what you're going to be positive for.
Probably, maybe a little bit of marijuana.
And what else?
That's it. I don't do anything else.
What do you do with the rest of your day other than marijuana?
I work.
Where?
I would work at Bohannon's.
All right. What do you do at Bohannon's?
I'm a dishwasher and trash stuff.
So you have a car accident and your go-to is to leave. Why would you leave a car accident?
Just everybody had left and I just left myself.
Well, no, everybody didn't leave because there were two
Yes,
people
there's-
remaining in the car trapped and somebody had to help them out. So why would you leave injured people behind in the vehicle?
I was one of those people injured in the car. And then I got out. They held me out and then I walked home.
Okay, this is not where he's gonna pretend he wasn't driving, is it?
We're pleading no contest, Your Honor.
Okay. So again, why would you leave someone behind in a vehicle that's injured?
You got out. Did you go to where they were sitting in the curb and speak with you?
No.
Okay.
No. Did you call for help for anyone? Why not?
Just being ignorant.
You see, let me just tell you what I know about life from my time on the planet. And I think I can say this because I have more of my life behind me than in front of me,
Yes.
is that big things somehow ends up snowballing for young people into bigger things. Number one, there shouldn't have been any speeding. Number two, nobody should have taken any drinks and driven. And number three, if there's an accident, you call somebody. If you would have stayed and helped, if you would have called somebody, guess what? We wouldn't be here for a failure to stop and render aid. So how are you getting around town without driving?
I take the bus, I'll walk if I have to. I have a daughter that I have to support, so I
How
gotta,
old is your daughter?
she just turned 1, March 13th.
Are you and the mother together or no?
Sort of, we talk, we're not married, so we don't live together.
Does anyone know the amount of what the restitution will be? Any idea?
I don't, Judge. I know our advocate is working on that. I don't know how much, if any, restitution is going to be outstanding.
All right. If there's an issue about restitution, just let the court know and we can have a restitution hearing.
Thank you, Judge.
How far did you go in school?
I stopped at 11th grade,
Why?
just struggling with my family.
What does that mean?
Like, I have to take care of my little brothers sometimes, most of the time, because my mom is just not healthy. So I'm really like their dad, and I'm always there to help them out and stuff like that. So
What do you mean she's not helping? Where is she?
she lives with her mom. Yeah, she lives with my grandmother.
And so how old is your little brother?
My little brother, he's 13.
So where is your little brother living?
He lives with me with my uncle.
So was child protective services involved?
Yeah, they're talking to my mother right now. So there's a case, I think, that's open with my mother.
So what are you planning on doing for the rest of your life? Are you gonna be working at Bohannon's or are you doing something else?
So no, I was gonna work at Bohannon's for a little bit until I get my own apartment, and then get my GED and eventually try to join into the military with my friend.
Well, I always tell people you can't keep saying you're gonna, because your gonna is gonna wake up and 5 years of your life will have passed you by. You understand? Cats 1 and 2, was there some sort of theft involved? Is there a reason for cats 1 and 2?
The case that was TIC was a burglary of a habitation, Judge.
All right, so here's the thing about burglary of habitations, right? I haven't been presented with any evidence, so I don't know what it says, but what I do know is that entering people's homes without their permission, it's going to end up resulting in one of two things for you. One, it's going to end up being a prison trip, and burglary of habitations, range of punishment is 2 to 20 years. Or either you're going to break into somebody's home and you're going to be shocked to find that they are at their home, and you may end up being shot or killed. And you know what people are going to say? It was justified. You're in somebody's home, you're not supposed to be. So I'm going to put down cats 1 and 2, but I can give you cats 1 and 2 course in 2 minutes. Don't take what does not belong to you, which people should have learned in preschool. And when you go to someone's home, only go if you're invited, and then when they ask you to leave, leave. Life is so simple, people make it so much difficult than it has to be. So cats 1 and 2. And the MRT, which is supposed to teach you right from wrong, which again, you should learn that in preschool, right? If everybody would treat others the way they would like to be treated, you would need the MRT course. So remember that as you're taking that course. I'm going to want him tested for levels. And those levels need to start going down. Do you understand?
Yes, Your Honor. Okay.
There should be regular Zoom recording. Mr. Madrone can hear you. Mr. Madrone, Ms. Pettis has some words to say to you. I require that everyone treat everyone with respect, so just listen and internalize what he's saying. You may proceed.
After everything, I don't think that you should be in prison or, but I did suffer injuries that are like for a lifetime. And I just want you to understand that because I did go through all of that, you do deserve to go through some kind of consequence. Did I cut off?
Yes, you did.
They keep calling me that, so I'm sorry. But yeah, that's all I have to say. But I do forgive you. Like, it happened. It's been a long time already, but I just didn't, I hope you just know where I'm coming from, James.
All right, thank you so much. Do you all need to speak with her?
I don't believe so. We have contact. We can talk to Ms. Pettis after this. Thank you, Ms. Pettis.
Thank you.
Thank you.
All right, probation will go over conditions with you. Court is calling 2024 CR 008124, 2024 CR 008173, and 2025 CR 007834, State versus Christian Alan Ruiz Garcia. Could I have parties announced for the record for the state?
Brandon Prada for the state.
Defense.
Raymond Martinez.
And are you Mr. Christian Alan Ruiz Garcia?
Yes, Your Honor.
All right. Defense has filed a motion in each of these cause numbers to dismiss for lack of due diligence and violations of right to speedy trial. All right, defense, it's your motion.
And Judge, I would ask the court to allow me to basically make this argument in all these cases. They're all one series of events that all happen together, so.
Any
it
objection?
wouldn't be any
None from the state.
All right, you may proceed, counsel.
But Judge, the court will recall, and I'll also bring up that one of the reasons for today's setting was to bring the defendant, who was a juvenile, who's now in TDC, to court because we want him to testify in our case.
Mhm.
We can't even accomplish that because nobody has his birth date. I don't have access to his birth date.
Mhm.
The state, and I'm assuming Norma was never able to
All right, and
obtain that information.
the court will note for the record that defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024.
specifically, well, I thought I had the specific date, but I don't, but the court has it before it. It's in June of 2024, Judge. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. A critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, I think everybody can agree that he's in essence a co-defendant, was charged in juvenile court.
And just one moment, State, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
And that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juveniles and since it was a certification, he was then sent to TDC, which we believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking from the very beginning, because he's a co-defendant and because he has his own set of discovery, and more importantly, in this case, he had other aggravated robberies in addition to the ones that were with my client. So our theory was, when it was our theory, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case, the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to help support our suggestion that he was operating under under duress. But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they, in fact, appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, Judge, we refuse to do what you're telling us to do. Okay, so we stepped back from that and we regrouped. We found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. And he denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client. But we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, the juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. Not sure they even got filed on.
And when you say other cases, you're speaking about your client's co-defendant.
Correct.
All right.
The co-defendant had double-digit number of aggravated robberies. And so the ones they chose to prosecute didn't coincide with my client's case, unfortunately. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need, but we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of court, I will tell you that his advice to this client is going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even if we were able to get him here, I don't believe we would have been very fruitful.
All right. And the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and no one had any objections to the prosecutors zooming in. And they informed the court that they would not comply with discovery. And so, State, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here, because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. Under 3914, if it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office. So everybody's responsible for discovery.
Judge, sorry if I could just chime in here, but I think like the distinction.
If you could announce.
Yes, it's Megan Galloway for the record. The distinction in this case is that there's a legal reason why it's not being provided. I believe under the family code, it's protected because the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other. So we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say, the petition to the juvenile court was still made, and that court determined that it should not be turned over. And so at this point,
and I know that the prosecutors in this court did all they could to get the information to defense. Is that correct? The attorneys in this
court, of course, Judge,
yes.
And I don't dispute anything that counsel just suggested to the court, but that could have been avoided. When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187, say, hey, we're getting ready to go forward on this guy. This is our deal. We're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I mean, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's being presented before me. And I want the record to be clear that the prosecutors in this courtroom did all they could to obtain the information that you were requesting.
I'm not disputing that, Judge.
And what I will say again, it appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. But I just want the record to be clear that the prosecutors in this court, I don't think, I know that you all did all you could to obtain the information.
then Judge, just to address one thing, the date of birth of the co-defendant was provided in the discovery that we received. So
okay, he should have that. Okay.
That.
All right. And I understand what you all are saying about the bench warrant with that. But we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we really doing? He can't present his defense And nobody knows, for the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that potentially.
It would help us to prove that point, we think, Judge.
Yeah. So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw, because I mean, that was his ruling. So at this point, my hands are tied because that was his ruling under the family code.
Mm-hmm.
And I would agree that neither party knows what is in those records that are over there. However, if we're getting to the point of, or their argument of duress, there are pieces of evidence where, in this case, that were turned over, like statements from the defendant that do address that if they would like to put it forward.
Mm-hmm. All righty. Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Thank you.
Your Honor.
All right, we're back on the record in 2024 CR 008124 and 2004 CR 008173 and 2025 CR 007834 State versus Christian Alan Ruiz Garcia. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. And it'll be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
No, Your Honor.
All right. Thank you.
Thank you, Judge.
Thank you, Your
Excused.
Honor.
And counsel.